Okay, we're live. Filming outdoor about issue spotting checklist about trusts and I'm sorry, wills. I already did the trust portion. Um, will substitutes and probative avoidance devices, non-probate transfer on death. Text definition: a will substitute is an arrangement respecting property or contract rights that is established during the donor's life, um, under which one, the right to possession on or enjoyment of the property or to a contractual payment shifts outside of probate to the donee at the donor's death, and to substantial lifetime rights of dominion and control, pos or enjoyment right retained by the donor. Control possession or enjoyment right retained by the donor. To be valid, a will substitute need not be executed in compliance with the statute formalities required for a will. Operation of law: as a matter of law, the title transfers to the beneficiary automatically on death and passes probate court. Purposes: probate can take 2 years and avoidance saves 12% in court costs. It's simpler, private, and more convenient. Examples of will substitutes are revocable trust, life insurance, naming trustee as the beneficiary, supplement. I've got multiple account holders, payable on death accounts that were founded in 1980, designation, registration of beneficiary, joint tenancy, Totten Trust, I don't know, TOD, probably transferable on death, and CP with right of survivorship. So community property with right of survivorship passed in 1990. Community property doesn't imply right of survivorship. The vehicle title can include PUD, or non-probate transfer. So right of survivorship doesn't have to just arise under community property. It can be just owners. And so all of that I just read is somewhat traceable back to family law. Restatement third of Uniform Probate Code 6-101 and Restatement third of Property 7.1. Revoking or amending will substitutes by a next page, later will. And this is valid per the Restatement Third of Trust, Section 63, Comment H in the Uniform Trust Code, Section 602, that was saying that it's valid to revoke or amend a will substitute by a later will. Now, I've got a table on the next page, and it is two-part. On the left side, when revocation by will is valid, and on the right side, when it's not. So a Totten Trust is valid in PA to revoke by will, whereas not anywhere else. And multiple party only in Washington by super will, and multiple party no will cannot alter a right of survivorship. So POD, payable on death, only in Washington by statute, subject to community property rights, whereas payable on death cannot be altered by a will. The right of, it says here, no will cannot alter right of survivorship. LI no, LI majority. I think that's life insurance. So can it be revocable by will, like say the beneficiary designation? And no, it can't. It's on both sides is no of this table. So joint tenancy, I think that's what JT means. It says yes under Will's doctrine of equitable election and is conditional. Joint tenancy, I would be valid to revoke by will under Will's doctrine of equitable election. Within the non-revocable by will part of the table, It says the majority restrict where a revocation by will, where it prevents injustice, device of ancient origin by which testamentary power over own property is extended to property owned by another. Living trust, yes, it may be revocable by later will if means written in trust or silence. Revoking or amending will substitutes governed by ERISA. ERISA supersedes all state law for employee-based pensions for nonconformity or for conformity. And FILIA, so ERISA is a statute, but FILIA is like the Veterans Affairs, Veterans Office, retirement benefits statute that governs benefits directed to veterans. And the case when this comes up is Metro Life Insurance Company versus Johnson, in which the life insurance policy post-divorce amendment was lost. Like, you called it in and you sent it in, maybe, or talked about it with someone over the phone at Metro Life Insurance and thought that they were taking care of it, and they didn't, and I lost documentation of it. So in Illinois, state law of substantial compliance suggested couple things to try to invalidate the gift to the ex-wife, I think. It says here, complementary dual state federal regs. In contrast, the daughter prefers preemption by conflicting convincing authority and affirmed for the daughter to benefit, right, from the life as the life insurance beneficiary. But it's only because of, like, that would be one rare circumstance, because I think the divorce, right, by operation of law, divorce can change a beneficiary on a life insurance policy. But if it was like a ERISA, like, which employee, if it was governed, if it was a type of life insurance policy that was governed by ERISA, changing the beneficiary, like, they strictly don't allow it, because it would have the effect of creating, like, conflicting results in the judicial courts. And the point is judicial efficiency, to basically strictly say that the beneficiary elected is the beneficiary, and that there isn't any extrinsic evidence to turn it, to change that. So, like I was saying, ERISA supersedes all state law for employee-based pensions for nonconformity. Notes to the case, the circuits are split. The Sixth Circuit has a federal common law pertaining to ERISA, and insured substantially complies with the change of beneficiary provisions of an ERISA life insurance policy when the insurance evidences his or her intent to make the change and attempts to effectuate the change by undertaking positive action, which is what happened in Johnson. And probably the Sixth Circuit was Ninth and the 10th division advanced by daughter went against this federal common law notion in the Sixth Circuit, holding that the beneficiary designation form should be signed per ERISA, followed by Bank M versus McMahon in 2000. In the Ninth Circuit, ERISA plans are preempted, for example, when conflicting cases uphold Slater statute, revocation or divorce revocation, or revocation by abuser or undue influence is chalked up to federal common law. Filia preemption was applied in the Hillman versus Moretta. That's an old case. Incorrect per uniform code as a frustration of decedent's intent. So the Hillman versus Moretta case is when the ex-wife of 10 years was still named beneficiary on a Veterans Affairs retirement benefit covered by Veterans Act, I might say, retirement benefit covered by FILIA. Rule is under supremacy clause of the Constitution, the federal law set to preempt conflicting state laws takes precedent. FILIA favors administrative convenience and therefore skips the step of paying out to the ex-wife in order for a widow to sue the ex. So, will substitutes anti-lapse is the next section. Page 31, there's only gonna be like 19 more pages. Restatement third of property, application of will doctrines to will substitutes. Although a will substitute need not be executed in compliance with the statutory formalities required for a will, such an arrangement is to the extent appropriately subject to substantive restrictions on testation and to rules of construction and other rules applicable to testamentary disposition. Anti-lapse now applies to all substitutes. All substitutes per Stirpes after Button and Anthony. Grant to a friend will lapse into residue of estate and trust and proceed to the residuary beneficiary, whereas a granted family will not lapse in the event a beneficiary predeceases the grantor. I think that's like really the only thing that I've learned that I feel I need to take away for the exam here is just when anti-lapse statute applies. That other stuff was great, but I feel like only this is important. Subject to substantive restrictions on testation and to rules of construction and other applicable to testamentary disposition. So there's a bunch of rules cited to restatement third of property, section 2.7.2, application of will doctrines and will substitutes, and lapse statutes from the Uniform Probate Code 2-702, 706, 707, Uniform Probate Code, Section 2-603, beneficiary designation, extensions to will substitutes. And the Button case first extended the anti-lapse statute to will substitutes by analogy and is preferred by the restatement third of property and restatement third of trust for inter vivos trusts. And the estate of T involved in inter vivos trust grant of trust residue to trustor's mother who predeceased settlor. And the common law favors lapse, which was applied at the appeal court level, but the statute for anti-lapse found more appropriate by the Supreme Court here because naturally the mother should predecease and therefore lapse intended for her heirs. So that sounds contrary to the rule that I'm supposed to remember. So where did that happen? I don't know what state that was in. It sounded like Supreme Court of either some state or the U.S. And I don't have a date on that either, if it was potentially outmoded. But First National Bank of Bar Harbor and versus Anthony, anti-lapse applied to inter vivos trusts based because settlor could have changed the legatee when the Benny passed, but didn't. Therefore, remainder interest to legatee was the present vested interest in legatee's family at time of legatee's death, supported by extrinsic evidence. So, I forgot to read here that a granted protected relative, grandparents, descendants of grandparents will not lapse. And UPC 2-603, Benny designation extensions to will substitutes, problems as designations for unborn or required to survive decedent per Stirpe stipulation, and to leave descendants in event no named survivor by right of representation. So I feel like I said, the most important thing to know here is that anti-lapse is going to apply to family members but not friends. And what that means is that if you're leaving a gift to a family member who predeceases you, the gift is still good. It goes to that individual's like heirs, next of kin. And for family members, for friends, it does not. It goes back to the testator's estate to be distributed by their will or will substitute or will. It applies to will substitutes, but that's the whole point of this section. And then, so someone who's designated in a will substitute predeceases the testator. If it's a family member, then the gift is going to go to their heirs. If it's a friend, it is going to go back to the estate, and the estate will be divided with all the other estate assets. So will substitute, change circumstances, divorce, and pour over will. I feel like the divorce I've already discussed, but in Clymer versus Mayo, revocation upon divorce was applied to trusts, but not former spouse's blood relatives application. So property prevented from passing to a former spouse because of revocation by divorce shall pass as if the former spouse failed to survive the descendant. So that's how you approach that. In the Uniform Probate Code Section 2-508, courts are split on extension of revocation by will being applicable to trust or will substitutes, therefore replaced UPC 2-804, will, trust, Benny designation, POA, TOD account, donative instrument of any type executed by a divorced individual before divorce, and extends to the former spouse's relatives. All right, Clymer versus Mayo. What really happened was there was a pour over trust, which was valid when, though no res passed by insurance policy award until decedent's death, parents appealed to prevent ex-husband from taking. Former Rule 2-511 allows the trust to benefit from grants devised from insurance company if named, even if corpus is unfunded. So it's still talking about trust, an unfunded trust. The pour over will substitute was going to give it its corpus, and that was probably given effect. What does it say? Receivement third of property extends revocation by divorce to will substitutes in common P. UPC 8-101B is retroactive to invalidate trust bennies that are former spouses, irrespective of the date of formation relative to date of divorce. Except ERISA plans are preempted. For example, when conflicting cases uphold Slayer statute revocation or divorce revocation or revocation by abuser or undue influence, it is chalked up to federal common law. Egelhoff versus Egelhoff, 2 months after divorce, the husband dies. The insurance is paid to the ex-wife per ERISA preemption over CIC state statute. In this case, there are children for the ex-wife to provide care. In the pour over will, it's still citing Clymer versus Mayo. And the UPC section 211 says receptacle need not have been funded during the testator's lifetime, but can be funded by a pour over device itself, or Uniform Trust Code section 411 by transfer of asset to trustee, but grant to trust taking effect upon settler's death. So I'm going to move on to a new section called Redemption by Extinction applied to will substitutes. So when I said that this was the wills section in earlier writing, it's still very much it's like will substitute. So it's kind of like, I think, like the precursor to trusts. And there's a really long section on elective share. Okay. So, all right, so let's read Redemption. Identity theory prevails over intent theory to strictly apply the rule or doctrine of redemption by extinction, even when it yields harsh results. What are these things? Intent theory, intent or motive of dissolution of specific legacy that is dissolved. Burden of proof on the legatee that was bequeathed the specific legacy to show the testamentary intent against redemption. California follows intent theory. Identity theory is specific legacy that is dissolved. That's all it says. Specific legacy is one which separates and distinguishes the property bequeathed from the other property of the testator so that it can be identified. It can only be satisfied by the thing bequeathed if that has no existence. When the bequest would otherwise become operative, the legacy has no effect. Rule: when a T disposes of the subject of the specific legacy or device during his life that is held to be a deemed, legacy must be in existence and owned by T at DOD. Case 64, Wasserman versus Cohen. Any action against trustee for distribution and proceeds from sale of apartment building that was intended for him but sold and by a pour over will added to trust. By identity theory, when T disposes during life the subject of a specific legacy or device in his will, that legacy is held to be deemed whenever the intent of testator legacy must be in the existence and owned by the testator at the time of the death. While some exceptions have emerged in the last 160 years, there is no cause to abandon the rule, however harsh, redemption now applied to the trusts. So that's an interesting fact set. The testator probably still wanted the apartment building to go to somebody else. They just kind of put it in the name of their trust because they were probably poorly advised. So must we go into Slayer statute? A good case on point is Neiman versus Herf, but they're pretty much everywhere. Is this the one about the constructive trust? No. So homicide, Slayer rule. Person who without legal excuse or justification is responsible for the felonious and intentional killing by a preponderance of evidence in the civil case and therefore is precluded from benefiting or profiting from the estate of the decedent. The definition may excuse insanity, defense of self or others, and killing out of mercy. Other reprehensible acts resulting in forfeiture of right as heir include abandonment, non-support, and bigamy. The majority requires murder or intentional homicide, whereas the minority requires murder finding. And the notes is that a felonious killing, intentional, desired, and or substantially certain by a preponderance of evidence is standard proof. If no criminal charge is required. So you prove this by a preponderance of evidence. You don't just like wait for the criminal case to be decided, right? This is a lesser standard than burden of proof that a killing of murder in criminal law. So what does that mean? Let's give an example because I actually have one. It's pretty clear to like everyone in the entire society that wife killed husband in some type of a domestic dispute with a gun. And no one's really prosecuting. I don't know if it's because the deceased is well liked in this community, or if it's because the wife has to take care of the child of the two. So they don't prosecute. But that doesn't stop, say, for instance, the father of the deceased from bringing an action under a Slayer statute that would prohibit her from inheriting from him. Because if by preponderance of evidence, the civil party can show enough for the jury to view there as having a felonious intentional killing, notwithstanding a criminal charge, the Slayer suit will prohibit the wife from inheriting from the husband, which is more likely than not probably the way that the husband's assets were distributed. Insanity does not work effect of a forfeiture. Severance of joint tenancy and tenancy by the entirety. So in option A, the killer retains a half share of the property for life. In option B, the killer retains a half share interest in the property and fee. And that's the majority followed or written in the Uniform Probate Code, Section 803, whereas in option C, it violates property law of vested rights. So I have a table of majority and minority views on this. So I'm going to read majority and skip minority. So killing constitutes murder. Okay, I'll read the minority too. Is killing constitutes murder or intentional homicide. Majority view requires a preponderance of evidence in a civil case, not necessary in criminal, whereas clear and convincing is required in minority states. Succession rights not denied if killing during insanity, whereas the killer forfeits his own property in a minority jurisdiction. Felonious and intentional is required in the majority, but in the minority, they might require assisted suicide, financial exploitation, abuse, neglect, or abandonment, which is like a lesser requirement. Succession by wills, for the Slayer stat to activate, to prohibit a gift, or to defeat a gift, to forfeit a gift. So succession by wills and intestate transfer are prohibited in all but a few states, including will substitutes per the Uniform Probate Code, life insurance, and revocable trust. So what does that mean? The way that we were talking about the way this affects it goes into effect is it backs the example is that if the father of the decedent had brought a civil action under the Slayer statute to prohibit and successfully wins against the wife to forfeit her, say for instance, right of survivorship over their house, a constructive trust is immediately created for the benefit actually of, the Slayer statute gives the effect of treating the wife as having predeceased the husband, which would mean that the husband's will or intestacy, the constructive trust would be for the benefit of his heirs and assigns, not hers. In either case, it's probably their one single son that they have together, but people have funny families lately, and things can be much different in other cases. But in that case, it's a little bit of a more simple one, and probably half ownership, and that's where this gets a little bit tricky, is to deprive the wife of her half share of the home because she's killed someone is actually a deprivation of property rights and unconstitutional. So she probably is going to keep a half share of the property, and her son is going to get the father's share. So it's probably that the familial home that was owned, we're assuming, by husband and wife by tenants in the entirety, with right of survivorship, the half interest that would have shifted by right of survivorship to fully be owned in title to the wife as the widow, is actually going to be half interest previously owned by the husband is going to be shift into a constructive trust that is going to be the wife as trustee for the son, more likely than not, as the heir of the decedent. And I have a distribution strategy here. Assets distributed according to the fiction that the killer predeceased the victim or killer disclaimed the interest in the Uniform Probate Code of Section 2-803, given the presumption theory that the murder severed the joint tenancy. Because the presumption is that the victim would have done so if she had the opportunity to change their will, they probably would have if they knew they were going to wind up being killed at the hands of the spouse. And so Slayer statute doesn't apply if the Slayer has a vested property right. So that's going to be it for page 35, because I'm not reading this Neiman versus horrific case. And then the last part of how this applies is show application of this principle when the killer kills someone other than the decedent in an effort to accelerate the time for his or her possession or remainder. Did the killer frustrate the order, and is the killer's right vested? So what they're trying to say here is, scratch the husband and wife tenants by the entirety with right of survivorship. Scratch that and say my grandmother leaves me her property, and through so did the killer frustrate the order? So reverse it. The son kills the father. No. anyway, frustrating the order in which the property is meant to pass to the killer. And is the killer's right vested? That could, if the killer has a right to property, then it would be already, like at the time of the killing, then it would be, and this would be like really remote chance of this happening, but like I said, it would be unconstitutional to take his property away just because he killed someone, because, you get prosecuted for murder, which has its own consequences besides property seizure. Simultaneous death applied liberty seizure. Simultaneous death applied to will substitutes, originally simultaneous or in a manner. The other thing that was being said here was that they actually, like, say for instance, that person goes to jail and they still own their half interest. So wife goes to jail, let's say, and her half interest, like, she still owns it, but she never gave the half interest to the son. It's just holding in a constructive trust until she gets around to it, because she's in prison. And I think they're trying to give the son the appreciation in the property value for all that time that the constructive trust was in existence, holding it but not passing it, so that the killer doesn't benefit from the appreciation of value during the time of the pendency of the case, and then some. Simultaneous death applied to will substitutes, originally simultaneous or in a manner impossible to determine who passed first, is assumed that the beneficiary predeceased the testator. So that's the rule. And what is impossible to determine? It's 120-hour period. So now, to be considered a survivor on the will substitute trust, the survival must be by 120-hour period, which is 5 days for people who suck at math. Janus versus Tarasowitz. This apparently is a really popular case that everyone's parents know about. It's a Tylenol case. And when the person whose life is insured and the beneficiary, so I'm not giving the facts, but the facts are that, like, these newlyweds die from bad Tylenol, because, like, they're super stressed out because on their honeymoon, like, the husband's brother died or something, and so the wife takes Tylenol, the husband asks for some, they both die from the Tylenol. And when the person whose life is insured and the benny of the policy die under circumstances in which there is no sufficient evidence that they died otherwise than simultaneously, then the policy proceeds are to be distributed as if the beneficiary preceded the insured, because they're both leaving an estate and they're now married, and so their family, who literally just marry them off, are like, well, we kind of want the property of the people who went into this marriage back. And so elective share, national view. In America, spouse protected from intentional. So this is a whole new section from simultaneous death. By the national view in America, the spouse protected from intentional disinheritance by elective share. Children sometimes protected from unintentional disinheritance. The partnership theory of marriage to comport to public policy is concerned regarding contribution of domestic labor, balancing both contributions to enriching marital life to accumulate wealth and rearing children. Marital sharing theory. Each spouse equally shares marital property. For example, property acquired by the couple during the marriage other than gift device or inheritance. Partnership theory, same as marital sharing theory. Each spouse owns an undivided half of marital and community property discludes the same, and property owned before marriage. Elective share are necessary in community property states that perform equitable distribution according to the community property regime. That's the partnership theory. I'm going to move to type 1. It sounds like the partnership theory of marriage. Partnership theory, which comes with this sort of marital sharing theory and partnership. Right. It sounds like this happens probably in California, a community property state. Whereas the conventional elective share is followed in all but one state that follows dower and courtesy, where Elsewhere, conventional election shares replaces down courtesy in all but a few states. Courtesy, which sometimes granted a life estate in the decedent state by conventional. There is a 1/3 interest in the decedent's estate. Everything H owns is in his name. There is no offset for wife's assets. Calculation: H's estate times 1/3 equals the wife's elective share. So that's the conventional method, followed in all but one state. Type 2 is the Uniform Probate Code's elective share. I find it hard to believe that's applied in 49 states, and there's yet 4 other theories, because that doesn't make sense unless some of these theories I'm about to talk about are not in circulation anymore. But they could be based on when they went out of circulation. They applied to a married couple who hasn't died yet. So you're going to apply the law of, like, I don't know, either the date of death or the date that they got married, or however these things work. But Uniform Probate Code elective share grant surviving spouse a right of election that implements the partnership theory for division of marital property at death. Partnership by approximation is 50% of the augmented estate by length of marriage. There's a sliding scale. For 0 to 90 years, 30% of all property is considered marital property. The fractional interest is applied. If the parties are married for 10 to 14 years, then 60% of all property is considered marital property, then fractional interest is applied. For 15 plus years of marriage, all property is considered marital property, then fractional interest is applied. Augmented estate, defined in 2-203 calculation, follows this like step-by-step. There's only 4 steps. I think I have in red an example. So these are the 4 steps to determine the augmented estate. Because remember, at the beginning of this, we were saying partnership by approximation, 50% of the augmented estate by length of marriage. So all of that stuff, the 30 to 60, and all property being marital property, on a sliding scale is, multiply that percentile to find marital property from the augmented estate. And the augmented estate is really the augmented estate, in short, is everything that makes up the estate, like adding back in all of the gifts and all of the non-probate assets that pass without having to go through the estate, and all of that gets added back in to give you like a real estate, rather than, as the augmented estate is kind of like, what is the real value of the decedent's property. So what you do is you take the decedent's net probate estate, which is netted out, right? And then you add back the non-probate transfers to others that are not the spouse. You include the spouse's non-probate transfers to the surviving spouse too. And then so you get a full number, property owned by the surviving spouse. So you add in their surviving spouse's property too, that would have been included in the surviving spouse's non-probate transfers to others had the spouse been the decedent. So you kind of like try to get a full figure of marital property, I guess. And then after you follow the steps to get this augmented estate, you then use the sliding scale by length of marriage to multiply by the augmented estate to determine what is the elective. Well, you don't just jump to elective share. You adjust by the surviving spouse's assets and then disparate wealth at the time of the short-lived marriage. Okay. I guess you just find the marital property portion based on the length of marriage. And the reason why you do that is because the disparate wealth at a time of a short-lived marriage between young people would be offset by contract or premarital agreement. Whereas like for people who've been married for like 15 years or something, like it's kind of more of an expectation, I guess, that they're not left like completely hapless and poor in old age when they of losing their spouse by natural causes. And public policy prefers that type of an outcome anyway. There's a contribution theory, implementation of a support theory, supplemental share. I've got it all like crossed out, all of it. And then protection against will substitutes, common law theories until Seifert. So note, Seifert versus Southern National Bank reversed for widow on question of in vivo's trust disposition if subject elective share is as included in augmented estate. So the rule of the state is if a married person domiciled in the state dies, the surviving spouse has a right of election to take an elective share 1/3 of the decedent's estate as computed by the UPC augmented estate, which was expanded by adding probate to decedent's probate estate, meaning that non-probate transfer is included. This is the trust that we're talking about that he left for like his son. So the court had to deliberate on the meaning of probate estate as departed from estate. Ultimately, public policy supports the elective share. So the court adds that trust is illusory. Illusory workaround to like get those assets out of the estate is basically why we follow the 4-part step to add everything back in to get the augmented estate. And then in the matter of Shiner pre-marriage treasury bill treatment. I already know where this is going. Under EPTL statute 5-1.1b, specific to savings bonds are not subject to right of election. That's just like the one carve out. Everything else is. Purchased after 1906 and not held in the name of like tenants in the entirety or with rights of survivorship by with us. So they're not held like in the name of both spouses by tenants in the entirety, therefore not subject to the election. Clarkson versus First National Bank, when the court is asked to define best interest surviving spouse that would cause guardian to make election for spousal share. Okay, so whoever the surviving spouse is got a guardian, and their guardian's stupid and didn't elect the elective share when they should have. And so can that be like imputed to the wife, or can she overturn that when she gets a guardian who's more informed? And I don't know the outcome. Probably yes. Protection against will substitutes, UPC 2-205 and 206. Common law theories until Seifert didn't apply elective share to will substitutes. Okay. I think, no, I didn't read this. Seifert made trusts subject to the elective share. That's why I went to that case. Illusory transfer test is the objective test from Seifert is now the predominant view applied. The fraudulent transfer test, subjective motive-driven test to recover trust validity from the Nell versus Price case reads, or quoting from the case, revocable trust not treated as inter vivos trust that is revocable depends on facts and circumstances. The revocable trust with life estate and surviving spouse is not viewed as illusory. ERISA circumvents REACT, spousal benefits. REACT of 1984 creates new spousal interest in form of non-employee survivorship rights, whereupon QJSA qualified joint and survivor annuity due to non-employee surviving spouse unless surviving spouse consents to another form. For example, if the employee dies before vesting of QJSA, the surviving spouse is due the annuity. And the Pension Protection Act of 2006 mandates qualified optional survivor annuity if the surviving spouse declines QPSA. And the REACT, this is an act, right? REA Act, defers to state law for divorce treatment, thereby circumventing ERISA anti-alienation preemption traits to allow pensions to be considered in divorce judgments. So that's interesting. Okay, in reaction to holding from Boggs versus Boggs, when anti-alienation gave new wife the pension benefit of the deceased wife who had preferred it to be transferred to her sons. All right. So like they're trying to get around the preemption by like making another federal law that says like, no, follow the state's law. So Elective Fraudulent Transfers Act UPC 2-205 and 207 from 1990 enumerates will substitute subject to statute elective share, including life insurance proceeds to others, the augmented estate calculation, D's net probate estate, that's decedents, non-probate transfers to others, decedents, non-probate transfers to surviving spouse's assets, and surviving spouse's non-probate transfers to other if surviving spouse had been the decedent. That's your calculation to figure out the augmented estate, and then you just kind of multiply it by the percentage based on length of marriage. And to be honest, I think that this applies in California, but then again, I have literally no idea because community property, what did I take first? If I took wills and trusts first, then I got this formula from wills and trusts. And then when I looked at it in community property, I was totally confused. Or the other way around. I got the calculation from community property and took wills and trusts and was completely confused because it didn't make sense. It didn't apply. So maybe what I'm saying is this is how all the other states do it. But under community property, they probably follow what we call the marital property, even though they don't call it marital property in any other place in the community property like textbooks. So I have a really hard time knowing what applies to where, and so I guess it's good that I know them both now because I just reviewed it, and I must have I learned that in community property. So yeah, so this augmented estate thing that applies in California because I probably spent like 20 minutes reading about it in community property once upon a time. Hagstad comes back in the homestead allowance section. Homestead is a protection from creditors for the surviving spouse ordered through probate. The family allowance can order payments to support the surviving spouse to maintain standard of living through the case, and statutes in the footnote, page 459 and 2. The UPC section 6-102, probate exemptions and allowances and non-probate transfers. UPC's homestead allowance provides a lump sum amount rather than a right to occupy the spouse's dwelling house as long as the surviving spouse or minor children wish to do so. Probate exemptions and allowances are neither charged against the elective share nor against devisees unless decedents will so directs. And restatement third of property, section 1.1 on the homestead is that the common law allowing widow to tarry in the chief house of her husband for 40 days is kind of the source law for this and source common law for this practice. And the jurisdiction gave 1 year right of occupancy or lump sum or longer right to occupy to the surviving spouse. UPC section 6.102b, probate exemptions and allowances and non-probate transfers, and Hagstead. So on page 42 now, no, I'm not. Community property. On page 41. Assets acquired from date of marriage to date of separation, except those assets that are acquired by gift, devise, bequest, or descent. Separate property begets separate property. Community property begets separate property. An example, lottery earnings proceeding from separate property equals separate property. Lottery earnings proceeding from community property equal community property. But you must prove it by tracing, which is easiest if you don't mingle the assets. If tracing cannot be done, then asset is presumed community property if acquiring during marriage. Hybrid assets has a separate property component that took on community property character after legal act of marriage and should be applied a fractional share apportionment by the Moore-Marsden formula for real property, which I've cited, but I don't have actually what that calculation is. And then date of separation, date of communication that marriage is irretrievably over. And in marriage, in remarriage of baragri, acting like married couple. This is a California case, actually. So they did their taxes together. They had dinner every night. They vacationed together. They gave the appearance of marriage, like going to dinner together and calling the one another their spouses. And she did his laundry, and thus they awarded. They said that the economic marriage date of separation, actually a good word to use, date of separation, was like not until like dissolution or something. So all the period that he was doing this and living in sin with another person, that the wife who put up with all of this is entitled to half of his wages as community property earnings, because the date of separation did not yet characterize his wages as separate property. So she ends up getting a lot more money. Premarital agreements. A right to elect to share a homestead and other family allowances may be waived under the PMC, which is probably the premarital agreement, marital agreements by contract law or specific statutes adopted in the state. See seminal cases. Wellington versus Rugg. A failure to disclose money at the time of the contract would not invalidate a premarital contract, which is like, really? Because that actually means that it's not voluntary most of the time. And then Roseberg versus Lipnick. Overturned Wellington. Okay, there you go. So that's not the case anymore. If you fail to disclose how much money you have when you're entering into a premarital contract, then the spouse that signed the premarital contract that's now aggrieved and coming to the court asking for the premarital agreement to be invalidated is going to be arguing that they didn't sign it voluntarily because they were unknowledgeable about half your assets that you left off of the disclosure of the assets that you had at the time that they got married. And that's the way that it's going to be treated in court, according to Roseberg versus Lipnick of 1979 in Massachusetts, which overturned Wellington versus Rugg, 1922 in Massachusetts. And Massachusetts is different, they say, but the same is going to be true in California, because California has its own special act statute for premarital agreements, and it's going to have that same effect. Simeon versus Simeon, prenuptial agreement is upheld even though wife received it right before the attorney, and waived right to review with attorney in Pennsylvania. Because justice held that women were advanced and should be held accountable to the contracts that they make unless there is evidence of full and fair disclosure of fraud, misrepresentation. They actually gave effect to the prenuptial agreement in Pennsylvania, as they should, because, you can't cry that you're like a weak woman that doesn't know any better on one hand and then argue for your rights on the other hand. Like, you kind of got to pick a side. Are you smart or not? Smart people don't need special exceptions. Disclosure of assets. Antenuptial agreements require fiduciary duty on disclosure of assets. Further, marital relationship is confidential. Prenuptial agreement is still arm's length. Confidential relationship standards are as follows. So fair and reasonable, as determined at the time of the contract, re-reviewed at the time of death and divorce, worth, literacy, business acumen, prior family ties and commitments. All of that, all of those factors will help you determine if at the time or at the time of the contract or at the time of death or divorce, if this was conscionable or fair and reasonable and fully informed of parties' worth. Kind of breaking that down, free of fraud, imposition, deception, overreaching, your time to review with a lawyer, outside counsel. Still not a requirement per Mattson of 1986, but there should be a special disclosure in the contract that you're consciously signing, knowing that you could view it with the attorney, but you're giving that up. Restatement third of property, section 9.4, no consideration for PMC and marital agreement, premarital agreement, marital agreement. I think anti-nuptial agreement would be your marital agreement. And so what I was just saying was that if you're doing a premarital agreement, you're bargaining at arm's length with your future spouse. If it's an anti-nuptial agreement, after the agreement, the spouses owe each other a fiduciary duty to already because of the marital relationship. So the antenuptial agreement, that fairness factors are going to be like really strongly scrutinized. You can't like withhold or information. You kind of owe your spouse like the duty of honesty and all types of other duties. No consideration. Right. Informed consent, no undue influence, recommend lawyer, pay costs. Uniform Premarital Agreement Act, the same. I think most of what I just read comes from probably the Uniform Premarital Agreement Act or the Uniform Premarital and Marital Contracts Act, UPMAA. Unenforceable by involuntary consent, under duress, no access to independent legal counsel per Section 9B, or no waiver of right of counsel per Section 9C. UPC 2-214 comports to the UPMAA. ERISA and REACT, how they apply a waiver of non-married spouse isn't valid consent to waive benefits in a qualified plan, and waivers required of spouse and witness at time of contract. I now remember the term quid pro. Quadro. Bonds. Okay, so the state of bonds, or bonds versus bonds, or whatever, marriage of bonds, Berry bonds, standard review in class, that there was no fiduciary duty, and at the time of the premarital agreement, and the legislation reacted to produce an anti-bonds enactment. So I didn't brief that case in my actual outline, but it really ought to go here. And so when the legislation reacted to the bond decision, which was more protective of Barry Bonds, probably because he paid for that, I want to say, just based on the way it went back and forth. I feel like it went in Bond's favor just because he's rich. And so 7 days ahead of the wedding is the mandatory kind of cooling off period, according to new legislation after the Bonds case. And in language, meaning that you can't have a spouse sign in English if that's not their functional language. And then waiving right to a lawyer must be in writing under a third party, or must explain contract in writing. Escape clause means the clause was unconscionable at the time of the contract. Terms of premarital agreement can't waive child support, perhaps spousal support. On page 44, Marvin Action cohabitation contract. I literally do not feel that should even exist. Totten Trust, named after New York, holding up legitimacy of the trust, revocable by the settlor, reachable by the creditors, automatically terminates if the beneficiary predeceases the account owner, inform the bank of the new beneficiary. That's all in the Totten Trust section. Pure and non-pure will substitutes. A living trust is pure or perfect because, as the settlor maintains total dominion and control, theoretically a transfer can be made, but the settlor may modify the trust during his life, revoke, change beneficiaries. Impure, imperfect is the opposite of pure. A probate avoidance will substitute, such as a co-owner of a mortgage or control is thus given up, i.e. to remove a co-owner, a quitclaim deed must be signed by the Benny. So what that means is my mom, put me on the name, or made me a co-owner on her property. So that's an impure will substitute, because though she's threatened to take me off of there, she can't. So it's not really pure or perfect. She can't theoretically just make a transfer if she wanted to. She needs to have my signature on it. Federal taxation of revocable trust. Untaxed until settler's death when trust has a tax ID of its own, substance over form. Example 8.1, no gift if no transfer. Double taxation. Corpus goes to the grantor's estate, not trustee, when grantor dies, rendering it ineffectual. General powers, restatement of trust, section 70A. In administration of a trust, a trustee A has except as limited by statute or in terms of the trust, the comprehensive described in section 85 to manage a trust and property and to carry out the terms and purposes of the trust. Section 85, in administering the trustee has all the powers over the trust as legally competent unmarried man has with respect to individually owned property, financial sophistication, spreading investment risks. So these are your powers, probably, of your trustee. Record keeping, tax implications, known position of trust, family member, drafting attorney. The specific powers appear to be set forth in the Uniform Trust Code of Section 816. RAP and U.S. RAP. No interest is good unless it must vest, if at all, within 21 years of the life and being at the time of the grant. Occasional judicial aberration limits duration. RAP is used as a proxy, and RAP limits remote vesting of contingent future interest. So no interest is good unless it must vest, if at all, within 21 years of a life and being at the time of the grant. Got that one done. Rules against pathogens. Trustee. Good faith is in execution of discretionary powers, even if unlimited, absolute, sole, uncontrolled term. Good faith in accord with purpose and terms of the trust and in interest of beneficiary. I have no idea what I'm talking about. Okay, good faith owed by the trustee is, there's got to be a better definition, but it says here, even if unlimited, absolute, sole, or uncontrolled term, like discretion given to the trustee, the trustee still must exercise good faith in accord with purpose, terms of trust, and in the interest of the beneficiary. Accord with purpose and terms and in the interest of the beneficiary. That's kind of what the good faith requirement is. And what I'm saying is it also applies to trustees that have discretion, full discretionary powers. Discretionary trust and emergency trust. I'm not even following. I'm just saying look at another section about discretionary trust and support, and difficulties include illnesses and accidents. Revocable trust. A self-declared trust is a trust in which the settlor acts as trustee, declares himself as trustee for the benefit of himself during his life, with remainder to go to the benny on his death, can cause difficulty under the present transfer test. See inter vivos trust. Inter vivos living trust is created by declaration of trust during settlor's life and exists at the time of death. See present transfer trust. Upon creation of the trust, the settlor transfers an equitable remainder interest in the trust property corpus to the beneficiary, remainder beneficiary. Matthias versus Fantin addresses merger theory to defeat the inter vivos trust, but merger theory later overcame by the temporal ownership of present and future interests, contemporaneous concurrent ownership of legal and equitable estates. I already went into that, so I'm not highlighting anything. Asset protection trust, protective trusts. So we're going back, circulating back into the spendthrift trust and discretionary trust are self-settled, is valid, but also alienable. Look at FTC versus Anderson, where the issue could not repatriate ill-gotten gain money from the Cook Island Trust because it restricted in the event of duress and made Anderson's role protectors of trust. Court subjects them to contempt. When contempt defense is an impossibility, the burden of proof is high when impossibility is self-induced. Example 2, Lawrence Options Dealer has $20 million judgment after losing an arbitration proceeding. Restatement, blah, 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 blah. Okay. Offshore APT appeared in British Commonwealth in 1980s. Bermuda, Bahamas, Cayman Island, Cook's Island Trust Act of 1984. I gave like the entire... So what is APT? APT stands for Asset Protection Trust. An example is the Cook Island International Trust Act of 1984. Another example, Domestic Asset Protection Trust in 16 states, including Alabama, Delaware, Nevada, Rhode Island, and experienced conflicts of law hardships. Restatement second of conflicts of laws. Washington developer opens a trust in Alabama, but Washington law governed Alabama due to having minimal relation to Alabama. Trust protectors in domestic APT allows the settler to exercise control over trustee while immunizing trust assets from creditor claims. In section UTC 808, the person other than the Benny who holds the power to direct is presumptively a fiduciary. No state imposes duties on third party, but duty from trust instrument. Protective trust gives the Benny a right to income, but upon attempt at voluntary, involuntary alienation of rights is forfeited as a protective blah, blah, blah. So what we're trying to get at is these generally, the spendthrift trust is like applied, the spendthrift provisions aren't always upheld everywhere, especially if you're like trying to like protect your money from literally the victims that you stole it from, let's say. And so what you do is, in order for spendthrift trust provisions to, like when on expatriated funds that are kind of quote outside of U.S. jurisdiction, trying to protect it from being repatriated, what you do is you have to like have an irrevocable trust, which is at formation. The irrevocable trust has its own tax ID number and acts as a tax shelter. But when in so doing, you end up having, which is followed in Colorado, Delaware, Hawaii, Missouri, Nevada, New Hampshire, Ohio, Oklahoma, Rhode Island, South Dakota, Tennessee, Utah, Virginia, New York, and Florida. But the problem is that you kind of lose control and you're sort of at the mercy of your trustee. And your trustee tends to have like, you know, all these trust powers with no, the only limitations that you can expect is like their own discretion. And that can be a very risky place for you to put a large sum of money. So I don't really recommend this to your clients. And there's lots of articles about it as an evolving area of law, but it's very risky. Revocable trusts become irrevocable after the settler dies. One thing to know about irrevocable trusts. REIT stand for Real Estate Investment Trusts. Testamentary trusts require writing and arise within a will if properly executed. The statute of wills I've cited here, restatement of trusts, blah, blah, requires clear and convincing evidence. I don't know of what, but you can read comment D of section 12.1 of the third statement, third property. I don't know anymore. I'm really about to be done here. There's only 2 more pages. Life insurance as a will, substitute, non-probate transfer, pension plan, multiple party and POD accounts. So these are all will substitutes again. Joint tenancy and tenancy by the entirety in land, TOD, bankruptcy and spendthrift trusts, as well as PCPA and BAPCPA and domestic APTs again, asset protection trusts again. So this won't be too long. For life insurance as a will substitute, look at the Will Hoyt versus People's Life Insurance case, ruling that the present transfer of future interest in contract statutory formalities of will not required. Courts gave effect to policy payout. Life insurance does not require statutory formality for wills. Life insurance bears a right to revoke or change beneficiary. Life insurance require pre-printed in the lapse clause. Life insurance usually outside creditor reach if insured dies in so one, except sometimes if specified members are named Beneficiaries. Type 1 is irrevocable life insurance trust, ILIT, policy ownership transferred to trustee. If funded, the other assets become pay premium. If unfunded, the settlor pays premium. And the trust type 2 is when the trustee is named Benny, now valid, but at one time it was controverted. And the statute's Uniform Trust Code section 113 allows the trustee an insurable interest in the settlor's life, which may have a tax advantage if trustee buys life insurance in the settlor's name and the settlor dies within 3 years. So, pension plan, employee-sponsored retirement plan, defined benefit, defined contribution, KIO, and an IRA are those examples of that. And then multiple party and for POD account, there's 4 types. One is joint accounts, life tenancy, lifetime Benny, and right of survivorship. Is A. B is lifetime Benny and no right of survivorship. And C is Taunton Trust, no lifetime Benny, but POD. Taunton Trust, and trust for another person, valid per majority, invalid from restatement third of trust, which is weird, but it's valid by the majority. And then POD account is the third type of multiple party POD and POD account. This is majority sees of right of survivorship by way of POD accounts, whereas the minority does not, and the owners share only their contribution. And third, valid testamentary, and should X right of survivorship to avoid taxable gift consequence during statute of limitation. Right, and then fourth, I don't know what V1 stands for, but right of survivorship by real property to rebuke incapacity, fraud, duress, creditor claims. And fifth, under this POD account, V2, 1989 legislated Article 6 revision, folding Taunton Trust accounts into the DEF and coverage of POD account definition and coverage of POD accounts, providing statutory forms for joint accounts with or without survivorship TOD accounts, and single name account designating an agent to act for the survivor owner, subjecting survivors' benefits and accounts covered by the legislation to an order check of any party who dies before the check is paid, and providing that when 2 persons named as parties to a survivorship joint account are married to each other and the account includes 1 or more additional parties, only the surviving spouse may receive additional ownership of account balances following the other spouse's death, and the 2-year statute of limitation is reduced to 1 year. Agency account is the 4th type of these multiple party accounts. Joint tenancy, a tenancy by the entirety in land, bears the right of survivorship by titling. Right of survivorship is severable by severance deed. Tenancy by the entirety is severed by conveyance, partition to third party. Probably didn't say it, but probably divorce, and usually not available to the creditors. The TOD, registration of securities, is just listed here. TOD deeds on interest in real property recognized in 19 states. Benny has no interest in property until owner dies. Then non-probate transfer, testamentary, bankruptcy, spendthrift trust, bankruptcy code 11 USC, blah, blah, 541. Property of the estate does not include any power that the debtor may exercise solely for the benefit of an entity other than the debtor. Bankruptcy court recognizes a spendthrift trust a restraint on the transfer of a beneficial interest of the debtor in a trust that is enforceable under applicable non-bankruptcy law, is enforceable in a case under this title. And then you get to the BAPCA. To prevent abuse of Section 707, Chapter 7, forgiving consumer debts per the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, if significant income is produced by a spendthrift trust, debt may not be discharged but delegated to Chapter 13 court-approved payoff plan. Bankruptcy Code amended in 2005, Section 548E1, bankruptcy trustee may avoid any transfer by the debtor to a self-settled spendthrift trust or similar device and made within 10 years before the filing of bankruptcy petition where the transfer was made with actual intent to hinder, delay, or defraud any entity to which the debtor was or became on or after the date of such transfer was made indebted.